I do have skills that make me a nightmare for people like you.
Hey guys, well it is, what is it, it's the 23rd today, 23rd of November, and what I got in the post today, Auckland Council, a big envelope and a little letter. So I'm going to start off with the little letter. So it's the 23rd we've received it, so what date's the letter? 19th, so 4 days ago. Dear Mark Norley, keen infringement notice 3066243825. Oh, CRN number 18090334821. That means there's a court reference number. Brilliant. Further to your letter dated the 13th of November 2018 follows: 1. Auckland Transport is in receipt of your hearing request and you will receive a formal notice of hearing in due course. 2. Our records confirm that the infringement notice was served by ordinary post on the 16th of October 2018. Well, I got it. I forget what the date was I got it. I think it was the 19th of November. No, 12th. I got it on the 24th of October, so it took them 12 days even though they issued it on the 16th. So you may wish to seek legal advice in relation to the methods of service available to enforcement authorities pursuant. I'm not an ant and you're not pursuing me. 2. Section 1392 of the Land Transport Act. Services, methods of service. In other words, they can post it, they can stick it under your wiper, or they can, they can hand it to you there and then. He chose to do it the cowardly way of not sticking it under the wiper blade, but just sending it out via mail. Irrespective, notice the saying further to my correspondence on the 13th of November. That's the second letter I wrote. They haven't referred to the correspondence on the 25th, other than to say that they'd reviewed the explanations when there wasn't any given. So, moving on. So, that's the letter saying we're giving you your court hearing after 2 fucking letters requesting it. Back in a minute. Okay, so I'm trying to find out. I've opened the big parcel, the court hearing procedures and all the rest of it. And here is what AT sent me. And I must say, they're more thorough than the police are. Vanessa Oliver, who is the prosecutor in this case, 19th of November I got a letter to her from saying, please be advised that your request for a hearing in respect of infringement notice issued blah 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 has been granted. You don't really have a choice of saying no. A first call hearing, in other words a preliminary hearing, has been set at Waitakere District Court on the following date, 25th of January 2019 at 10 AM in the morning. I'll be there 9:30 at least onwards. So come one, come many. Anyone who's interested in actually watching and seeing how this works, 25th of January 2019 at Waitakere District Court, which is 9 to 11 Ratanui Street in Henderson. By all means, come along, more the merrier. I know of at least a few people that are wanting to attend. So she sent me that, and attached to it is the notice in respect of an infringement offence, which is, well, notice of hearing in respect of an infringement offence under section 21(6) and 7 and 8 of the Summary Proceedings Act, which we all know is quite well. States an infringement notice was issued on the 16th of October by Auckland Transport and served on the defendant on the 16th of October by ordinary post. So he issued that infringement notice 4 days after the photo was taken. Why didn't he do it on the day? An infringement notice alleges that on the 12th of October, Ratanui Street in Henderson, that I breached 3 separate different rules and regulations. The defendant by notice in writing signed by the defendant and delivered to the informant requesting a court hearing in respect. The defendant did not in that notice admit liability. Why would I? Because I'm not liable of anything, I'm innocent. In respect of the alleged offence, accordingly a matter will be heard by the Waitakere District Court on the 25th of January. Now, you're thinking parking ticket, they're just going to stick me in front of a JP or two justices of the peace. It's usually one doing the ruling and the one taking the notes and always telling you to be quiet and slow down so he can take all the notes down. However, you know, I'd be more happy in front of a judge, to be quite honest. And I know JPs do have jurisdiction over Category 1 offences, just infringements. However, like last time with the $80 ticket, I think I might just put in a request to record the hearing as well. And then all of a sudden I might end up getting put on a judge's list. So that's one way of confirming that I'm going to be in front of a judge and not an uneducated justice of the peace that doesn't know jack from shit. So that's from her. They've given the address of 6 Henderson Valley Road, Henderson, to respond. They must give a physical address for you to send postage back to, although they haven't supplied any sort of email address. The next letter, again on the 19th of November from Vanessa, looks like she's been having fun, and they're all personally hand-signed and everything, with a little smiley face and everything. Please find enclosed a copy of all relevant information held by the prosecutor. The information also includes any information that would be required to be disclosed under sections 12.2, which is further information in regards to initial disclosure, and section 13.1 of the Act. The Act, I am guessing here because she hasn't actually stated what the Act is, but the Act is the Criminal Disclosure Act 2008, and she's referring to that. Also enclosed is an investigation file index which describes all documents of relevance of the file, and where documents are not disclosed identifies the reasons for their non-disclosure. If you wish to discuss this matter, please contact the writer, Vanessa Oliver. Believe me, I will be. I'm going to be ringing up AT soon and just asking for her contact details and email address. So now it's just ringing up AT and ask them if there's an email address I can use to contact Vanessa Oliver direct, or an email address to the prosecution service that I can contact. Let's see if they're going to give me some sort of joy there. They should do. It's only an email address I'm asking for. It's not like I'm asking for their blood. 355 3553. Ring.
Kia ora and welcome to Auckland Transport.
Thank you.
Please select one of the following 3 options. For inquiries about buses, trains, ferries and hopcards, please press 1. For parking and infringement inquiries, press 2. For all other inquiries, please hold.
Just hold.
Please note, your call may be recorded for verification and training purposes.
Excellent.
Auckland Transport, Maria speaking.
G'day Maria, how are you?
I'm good, thank you.
Awesome, awesome. I'm trying to find out an email address for a parking prosecutor that's just sent me some disclosure.
Okay, what was the name there?
Vanessa Oliver.
Let's see if I can bring it. Okay, so email address. So that would be Vanessa Oliver. So this will all be in lowercase.
Yep,
So it'll be vanessa.oliver
yep,
at at
yep.
.govt.nz.
I've actually tried sending it to that already as a hesitated guess, and it's bounced back at me.
Have you got the spelling as, because that's what we've got here, those are the only email addresses that we hold.
Okay, so it's
So,
V-A-N or double N?
just one.
One, so V-A-N-E-S-S-A dot O-L-I-V-E-R at at.gov.nz.
So O-L-I-V-I-E-R?
Ah, Olivia.
Yes, that's what we've got here in the system.
So O-L-I-V-I-E-R.
Correct.
It's that second I I've missed. Perhaps I didn't read it
I
properly.
do. You wouldn't know that, because I wouldn't have known either if I wasn't looking at it myself.
Yeah, exactly. I'll just have a look at her letter here and see. Yeah, you're right. I just looked at her letter and her signature, and it's definitely got that second I, so that's where I'm going wrong. Thank you so much, Maria. That's,
You're welcome. Was that all for today?
yep, that's it.
All right,
Fantastic.
have a great weekend.
You too, eh?
All
Bye.
right, thank you. Bye.
And there's a disclosure index. See, Mike McMurtry. This is what you call proper prosecuting. You know, actually supplying a full disclosure index or a disclosure index. Now, there's the first call letter on the 19th of November, which I've just given you there. Notice of hearing, which is the second page I showed you. Prosecutor's disclosure letter, which is the one I just read you about sections 12.2 and 13.1. Caption sheet. Stationary vehicle offence infringement. Defendant's letters received on the 29th of October. So I was right, and there's 3 pages there. See, that's not entirely accurate because that was over a 5-page letter and it had photographs showing the white markings, so they've left things out there. The adjudicator's letter dated on the 3rd of November, where they're telling me thank you for my explanation, which I never gave, and thanking me for the correspondence, which the lovely lady on the phone, I can't remember her name, tried to tell me they never received. Defendant's emails received on the 13th, which was the day I rang them back. 21 pages there because I sent them quite a few pages of law. Infringement notice details printed on the 14th of the 11th, so it looks like that's a reminder, although I don't know why. Enlargements of photos taken by the warden on the 12th of the 10th, there's 2 of them, and enlargements of the photos taken by the warden. He went back on the 15th of November and took 3 photos of the parking space empty. And in those photos you can clearly see the white hockey stick marks defining a white parking space. He mentions in his notes that there is a P90 area. If it isn't a P90 area, why is it signposted that it is, given that the only other 2 spots there are in a squared out loading zone, which also has white hockey sticks in it. So, yeah, very confusing markings. Perhaps Auckland Council would like to go around there with this water blaster and get rid of the white lines so these tickets can become legal. Just a suggestion. Then people might not park there all the time when they see white marks. Just saying. New Zealand Transport Association motor check, vehicle registered owner, where it shows 2 registered owners, not 1. Burden of proof, beyond reasonable doubt and all that, criminal standard. And a draft exhibit list. Okay, so there's the caption sheet, which is summary of facts. It's got the maximum penalty fine here, which was required under the initial disclosure of $1,000, so they can sting me up to $1,000 for this. Did stop or stand in the vehicle parked on the road marked by broken yellow lines, and then they've put Rule 6.44 Land Transport Road User Rules, Section 40 Land Transport Act, and Rule 4 of the Land Transport Offences and Penalties Regulations. So there's the provisions, that's the nature and cause. They've supplied it on the summary, and they've also supplied it on the notice in respect of infringement. So it's not an invalid charging document. Well done. You did better than the New Zealand Police did. Summary of facts. The roadway opposite Harvey Norman on Ratanui Street, Henderson, is marked with broken yellow lines. Is it now? Is it marked with white lines as well? At approximately 3:44 on Friday the 12th of October, and Auckland Transport Parking Warden observed vehicle registration parked on broken yellow lines. The broken yellow lines were clearly visible. Were they? Were clear and visible. The officer took photographs of the vehicle parked on broken yellow lines. No, he didn't. He took photos of a vehicle from 15 metres away and it doesn't show any broken yellow lines. Auckland Transport issue notice number 306 and served the notice on the defendant by ordinary post on the 16th of October, which I received on the 21st or 3rd, or 24th, sorry, so it took them 8 days for that to get to me by post, after issuing it 4 days after the infringement occurred. They never issued a ticket on the day. They waited 4 days and then did it then. So why didn't he just print one out and stick it under the wiper blade? Could someone have been sitting in the car the entire time? Anyway, moving on. So that's what they sent me. Now they've sent me a copy of the original notice, 2 pages, the information on the back. If you want to be a slave, this is how you pay them. They've sent me the 19th of November, demarcating, further to your letter dated 30th of November. This is just the cover note. Auckland Transport, in receipt of your hearing, you will receive a formal notice in due course. Our records confirm that the infringement notice was served by ordinary post on the 16th of October. You may wish to seek legal advice, and then they're pointing out pursuant to section 1392 of the Land Transport Act, saying basically they can either send you the notice or they can post it to you or they can deliver it by hand. It's just their postage options and what is deemed a valid service. Well, there's no debate over that. It's just the simple fact that why didn't he dish it out on the day? Kind of curious as to that one. Could he be that he was a chicken shit coward and didn't want to come up to the car where someone was sitting in it? Possibly. Or perhaps someone was standing next to it talking to another friend that happened to be there at the time as well. Yeah, who knows? And then of course they've sent me the letter on the 25th of October, which shows my 2-page letter, but then there was also 3 or 4 other pages with photographs attached, which they haven't included. So what, the printer run out of ink or something? They can print bloody good photo quality printers when they want to, but they can't print my stuff. So that's a bit deceptive, isn't it? I'll make sure I bring a copy of that along for my records and ask them why they don't have it. Then there's the 3rd of November letter that we got from them. That where they're saying thank you for your correspondence after reviewing your explanation, which I didn't give, and the 2 photos that the warden took. You can see the cabbage tree here. He's a good 15 metres away from the car, and you can't actually see broken yellow lines by the car at all, just up to it but not under it. So gee, that's not very good. And there's another pretty fucking crappy photo there too. After that, she's then sent me the 21-page email that I sent them on the 13th, where basically it's my 13th of November letter, which I've read out to you guys in part 4, I think, or part 3, where I sent to them by email. So this just goes to show sending it by email is a valid way of service. The photos that I've supplied, the parking 90 sign that I went back and took, the New Zealand Bill of Rights Act, where I cannot be compelled to become a witness. The notice that was on the front of my windscreen there that they took, therefore they owe me $75 for issuing a notice. The Criminal Disclosure Act as well. See, all of this was in that first letter, which they didn't supply. Okay. And then they've sent me a copy again of the 3rd of November notice, thanking me for my correspondence. Talk about double-ups. Then they've sent me the scanned copy of the letter of the photo they sent me. You can tell by the crease lines in the picture. Then they've sent me a copy of the court request where they're asking you to plead and take responsibility. Then they've sent a copy of that, a blown up copy of what's on the windscreen and on the rear windscreen of the vehicle. New Zealand Bill of Rights Act Section 25, Minimum Standards of Criminal Procedure, and New Zealand Bill of Rights Act Section 24, Rights of Persons Charged, where I am presumed innocent and need to be known the cause and nature. And also, interpreter of shall have the right to have free assistance of an interpreter if the person cannot understand or speak the language used in courts. And we're not talking English, are we, people? Criminal Disclosure Act, Section 12, just in case she's a little bit confused. And there's 3 pages there of that. The Summary Procedures Act, 1957, Section 21, and where I point out in Section 6, where all I need to do is request in writing and sign it and send it to their address, and I get a court hearing. I don't have to fill out their request forms. I don't have to go online and confess guilt that way either. You can just request a hearing without opening your mouth and sinking yourself in the process. And then there's just more and more pages. And that's the 21-page email that I sent them on the 13th. Hope they enjoyed reading that one. And then what they've supplied me is the 2 copies of the original photo that the warden took at 1541 and 1542, and yet he claims he's issued the infringement at 1544 on the 12th of October, and yet it wasn't issued until the 16th. So why's that? Why 4 days later? And then the pretty photos of where he's gone back, and he's taken a photo of the empty car park where you can clearly see, yes, there are broken yellow lines, and yes, there are white hockey sticks also marking a white car park. And he's taken it from this side. You can clearly see the white marking there. So there's no doubt in my mind. And why isn't he dishing up tickets to the other 2 cars in that picture? Same with this one. Okay, so the other 3 photos he went back a month later and took. The New Zealand Land Transport Agency, in other words, the details of the registered owner, where it states, oh shit, there's 2 people that are registered owners. So that's interesting. Shit, we've had it since August 2009. We've had the car almost 10 years. Shocking. Okay, and then there's a draft exhibit list saying there's the photographs taken by the warden on the 12th of the 10th, photographs taken by the warden on the 15th of the 11th, and the NZTA owner vehicle check, which is what I just showed you. And then there's the record details here, where this is what the notes made at the time of the incident by the parking warden and what's entered into PinForce. Okay, PinForce is the program they use to look up your details. Where it is, what it's called an offence P107, so fuck knows what that means in their records, but this is just for internal use. Parked in an area marked with broken yellow lines, opposite Harvey Norman's, and it says here, driver returned yes. Comparable issue time 1544, completed yes. Well, if it was issued, why haven't I got a ticket anywhere stating 12th that it was issued? If they actually issued it on the 16th, why don't I have one saying from the 16th? Why did they backdate it? Perhaps they should have done it at the time. So a bit sneaky there to think that they can take a photo and then 4 days later issue the infringement and backdate it. So there's all of that stuff there. And there's little notes, one here, broken yellow lines visible, fixed point, VF question mark, in other words vehicle front question mark, meterage 2 question mark, 1 metre to the front, and vehicle entrance of courthouse fixed point, VR vehicle rear question mark, M2 question mark, 7 metres to rear, and P90 restriction sign over sign, driver returned and drove off. Did it? Did the driver? Oh, okay, so there's got to be a brief from a witness, then there must be a witness statement or a brief from a witness. Perhaps there's a witness list somewhere. It should show the identities of the first-hand verifiable witness that can take the stand and verify all of these wonderful pieces of paper. You can say it under oath. So I don't see a witness list. I don't see a witness listed anywhere. And just let me check here. I'm pretty damn certain that if I look up, now let's see here, we'll go to legislation.govt.nz, we'll go to the Criminal Disclosure Act 2008, and we'll go down to section 13 here, full disclosure, section 13. The prosecutor must disclose to the defendant the information relevant. Now granted, he doesn't have to give me full disclosure until it's reached, until they've had a preliminary hearing. So in fairness, they don't have to supply it to me yet.
But here we go. Section 13.3. The standard information referred to in subsection 2A is A copy of any statement made by a prosecution witness, and a copy of any brief of evidence that has been prepared in relation to the prosecution witness, and C, the name and, if disclosure is authorised under section 17, the address of any person interviewed by the prosecutor who gave relevant information and whom the prosecutor does not intend to call as a witness. So even if you're not going to call them as a witness, you've got to supply me the name so I can go and question them, because the defence has a right to also interview the witnesses as well, do they not? Any written account of interview, whether signed or unsigned, by any other record of interview, any statement made to the prosecutor by the person, any convictions of the prosecution's witness. So that's an interesting question. Has their witness got any criminal convictions? We'll have to find that out, won't we, people? So yeah, I'm going to be going through, in fact, let's just reprint out section 13. So I've got it fresh in my mind. And yeah, I'll make sure I go through that with a fine-tooth comb and ask them for any more relevant information and tell them that that's what I'm expecting, should it come through to a not guilty plea and go through to a defended hearing. And at this point I'm still innocent. I'm still wondering, you know, where's the evidence? There's no evidence that I was there at all, other than apparently now notes in a record saying that the driver returned and left. And that driver hasn't been identified as me. Just the driver did. So who's going to identify the driver as me? Interesting question, that. I wonder how many tickets that guy issued that day. I wonder how many people he visually can identify in one day. You know? Alright, so Criminal Disclosure Act, we're going to be going through that a little bit more. But anyway, under section 12.1, she supplied the minimum, she supplied a summary of facts, she supplied the offence, she supplied the cause and nature, so they've done everything right there. All they need now is to supply a witness that can first-hand identify myself as the driver of the vehicle at that time, and then explain why they're dishing out tickets when a car's parked in a white painted hockey stick mark for a P90 area. That would be a really interesting question. So either way, put them through their ringer, make sure they earn their money, and yeah, I'll put a little submission into Waitakere District Court as well, just a submission to request to record the proceedings as well, and let them know that I'm expecting a court transcript, and perhaps if they want to put me on a judge's list to discuss the matter further, that'd be fantastic too. Alright, I'll catch you all later on. I'll scan all this shit up and put it up through the spiel. Alright, until then, have a good one. See ya.
The world's on fire, 'cause they lit the spark.